Hi friends, USCIS just issued a new memo clarifying guidelines as to conditional residence status, when to submit for removal of the conditions, what regarded to be timely submission and what's going to be untimely submission, and most importantly, when a person who lost their conditional residence status may file for adjustment of status. Well, first of all, of course, you know already that if you are filing for a marriage-based green card, one of the requirements is to prove that that marriage is real and legal. It has to be legal under the laws of the place where the marriage took place. It should not be done for immigration purposes, and you should not be paying money to anyone in connection with that marriage. The guidelines further talk about two different ways somebody can file for removal of the conditions from their family-based green card, based on a joint filing or based on a waiver filing. The guidelines again state that removal of the condition petition based on a joint filing must be filed within 90 days prior to the second anniversary of your conditional green card. But if you are late, depending on the reason, the government may forgive you. Generally speaking, forgetting to file the petition is not going to be considered a good reason. Unlike joint filing, waiver-based filing can be filed at any time. Interestingly enough, conditional permanent resident does not have to be in the United States to file a petition to remove the conditions. The new guidelines explain that you can file I-751 joint or waiver-based petitions with USCIS up until the time you have final order of removal. This is very, very important. But of course, the most interesting information about these new guidelines is in the very end. It says that even though the regulations require that an applicant be eligible for the requested benefit at the time of filing, the Immigration and Nationality Act provides that the conditional permanent resident status terminates as a matter of law as of the second anniversary of the non-citizen's lawful admission for permanent residence. Why is it important? It is important because the same guidelines state that when your conditional residence status terminates, you can file for adjustment of status based on a new basis. For example, petition by a new spouse. There was a lot of confusion in the legal community as to when exactly a person who remarried again but previously held conditional status may file for a new adjustment of status. Do they have to wait for the judge to terminate their conditional status? Do they have to wait for the notice by USCIS that their status was terminated to file for new adjustment of status based on a new petition? So this little paragraph in the end seems to state that you don't have to wait for either of those things to happen. You can file for adjustment of status when your conditional residence status terminated as a matter of law, and it happens as of second anniversary of the non-citizen's lawful admission for permanent residence. The lack of notice in this instance generally does not create any undue harm to the person because the person is relying on the fact that the status has been terminated to be eligible for the benefit sought. So, do we really now finally have a clear guidelines that as soon as your 2-year green card expired and you did not file petition to remove conditions, but now you are remarried, you can proceed with a new adjustment of status? Well, that's what I get from these guidelines. What do you think?